The Investigator Online TV. Like, share, and subscribe. Welcome to our legal debrief. And with me on set is
Daniel Bitature, the Prince of Journalism. Thank you.
You're welcome. Our insider legal brain.
Ndawula, Nkomao.
Batugamba nti bwoba okola ogenda kusigninga legal document ezo zijeke zonna those initials must be in full.
No. It is erinyo of course libako. Signature is also attached. Na initials ozikoyesa ku pages. You could sign on every page or initial on every page. Na you know when Mulude mu field, so you've come up with a brand of names that fit you. I've not yet started. I cannot just say Ndawula this and then the next year I'm going to hold it and I did this, I force that. So I'll just stop at Ndawula. It suffices for now.
You're welcome, boss. And I'm yours truly, Jaco David Waluka, 24/7 like an AK-47. We are going to be discussing about the embassy in between Moneybags, Patrick Bitature, his financial empire, and legal issues, and the legal dynamics behind the quest of General Muhoozi Kainerugaba's bid for the presidential seat in 2026. Mr. Ndawula, General Muhoozi Kainerugaba, at 49 years of age, is now a presidential advisor on military issues. He's still a serving army officer. He was a commander of the Elite Special Forces Command, SFC, and now is the leader of his own personal youth army, his fanatics. It is actually not an armed outfit. Jabaita MK army. First of all, there are legalities as regards a serving military officer, of which Muhoozi is, and in truth of the matter, he is a 5-star general. Article 208 stroke 2 states that the UPDF shall be non-partisan, national in character, patriotic, disciplined, and subordinate to the civilian head of state or anybody holding power at that time. These things that General Muhoozi is doing at the moment, don't they say otherwise of this article 208 of our constitution?
Not to use a lot of English na ekibuzo kyo kyonna kiri mu Lungereza.
Ate munnaye bwe naba sinafuna gundi engeri gye bakitabuseemu mu Luganda article 208 kyova olaba tusooka ne tuyingira mu Luzungu.
Yeah, I think it's actually obvious. Bobera ngoli mnamaje, same thing happened with Kano Kizza Besigye. And I think, who was it? It's a Jusa.
By then he was called David Tinyefuza.
So, when you bobo gendo ku you're taking a political office, obo ino soka nova mu maje. Systeming, of course, mu kawairo bibiri munana, that is non-partisan. Into the armed forces must be non-partisan. But tunulira Uganda jevudde je twatandikira twafunanga nnyo ekizibu kyaki military governments nti whoever has the armed forces has power. kyova olaba nti bw'atunuulira engeri Obote 1 gye yavaawo, how was it, yali Singapore ne bamukubira nti mukama waffe tokomawo mu ggwanga, eggwanga terikyali liryo. So bw'olaba engeri gye bajja okutuuka ku constitution, when you look at the preamble, kyewaliise introduction mu lulimi olwangu, kyewaliise introduction mu lulimi olwangu, the preamble kugamba nti they recognize, right? Recognizing nga gye bavudde, they recognize the issues of human rights violations, and it is that backdrop okwo kwennyini kuba besinga ne bagamba nti kati tuleese provisions zino, tuleese ssemateeka ono okutugaidinga mu ngeri gye tugenda okukwasaganya ebintu bya government. So bwe baleeta that non-partisan provision, those were some of the considerations. Nti if you have kyekintu kyekimu ekibarring traditional leaders from participating in politics, nti you still had that issue, a king, they have loyalty from their subjects, and now they are taking political office. So you prevent certain classes of people from taking political office, so that, because singa kati ogamba nti general wa NRM president and you have multi-party politics, olaba aliko kati apparently there is no direct affiliation to the army besides the history and him being commander-in-chief. But even then, olaba nti there are places NRM can go that NUP cannot. Waliwo webateeka ekipande ky'omukulu ku certain roundabout, omuntu omu n'akikuba ekifaananyi n'ateekako caption nti olaba Uganda eri free, mwali badde muteekawo n'ekyakyagulanyi tewali agenda kikwatako. But of course he was speaking sarcastically, n'agamba nti singa ekyo kibadde kya muntu mulala kyali badde kikola ki kijjibwawo. Kati if you have that kind of environment where the president is apparently civilian, naye ng'era there is that influence, how much more bw'obeera ne president ali directly in military office. So kwe kuleeta that issue. Of course, constitution mu lulimi lwayo, it does not prevent an officer of the army from pursuing political office. It just talks about non-partisan, a non-partisan army. So we tujja ekyokugamba nti a police officer does not participate in politics, the UPDF Act. Kubanga bw'otunuulira that provision akawaayiro 28, it will talk about the non-partisan element. Then kajja kagamba nti parliament erina olukusa oba the authority okola amateeka ageekuusa ku nkwasaganya y'emirimu egya UPDF. So it is under that authority, of course, ng'ogaseko akawaayiro 79 ne bajja ne bakola etteeka lya UPDF Act erya 2005 ne bateeka under that Act section 99. It is now more specific under that Act. Nti bw'oba ogenda, if you're a military officer or a militant and you're going to pursue political office, you first resign, you first retire. So for as long as you have not retired, you cannot pursue political office. And of course, that section in the UPDF Act is operating in light of Article 208. So that is where you can base. No guarantee legally, MK tasobola kubanga akola campaigns, MK tasobola kubanga is declaring interest in the presidency. I mean, if it was any other officer, bayinza nokuba mu court martial.
Why do you say any other officer? However, even before you answer that, botunuulira some of the people in the current government, for example, the former CDF, General David Muhoozi, is holding a ministry at the moment. There is General Katumba Wamala and General Jeje Odongo. why is it that General David Muhoozi can be appointed minister, all these others, and then Muhoozi cannot pursue the other the same political angle? Is there a difference between a political appointment and no muntu nga General MK agamba mutino yagenda?
I think kibuuzo ekyo nyinza obutakiddamu authoritatively nti nkiddamu mu ngeri y'amateeka, nyinza okukiddamu nga bwe nyinza okitegeera. So mu mateeka you'll mostly consider definitions. What does the word mean? So obagamba nti political office. So the question becomes, okay, kati bw'oba appointing these generals, right? Otaddewo general so and so. Of course, even they have representatives in the parliament, the soldiers. Naye, what then do they mean by political office? So if we are looking at it as, okay, you can appoint a minister as a general as a minister, but then you're saying that a police or a military office or a militant cannot pursue political office. Kiba kitegeeza nti yakola etteeka eryo we yali atunuulira what you call political office, alina offices z'ataateekamu under that category. So nga we ngambye kiriko disclaimer, sikyogerayo on the basis of law, because naye mu ntegeera yange it is to the effect that political office is an elective office gye baba boogerako. Kubanga kati bwonna agamba nti omukulembeze tasobola ku appointing generals, you're leaving out a whole section of people that are not catered for. Nti ogenze mu cabinet meeting, you're discussing issues of the military with civilian personnel that might come, bayinza okola ebintu oba bayinza okola policy issues, policy framework ekwata kwaba abantu naye nga ate they are not present in the room. So it would be acceptable, right, under good governance, okuleta on board military officers to serve under appointed offices. So the appointed office may not necessarily mean a political office. Naye ekitaliko kubuusabuusa is that if it is an elective office, then it amounts to a political office. Omuntu ali mu magye gy'atakkirizibwa kupursuinga under section 99. So it will hinge on what you mean by political office. Naye nga ekya president at least ekyo kyo tuli sure nti that is the highest political office in the country, because oba olondeddwa abantu bonna abantu abagenda mu parliament, for the generals that go to parliament tebalondebwa bantu ba bulijjo. So there is a difference between offices ezirondebwa abantu aba bulijjo nezo ezeekuusa ku magye specifically. So I think oyinza okuleeta mu distinction eyo nti if any of those generals, General Katumba, bw'agamba nti ayagala kufuuka president, he will still have to resign, because if I understand what Parliament may have intended, it would be that an office that is elective, especially where the election is conducted by the public, nti abantu ba bulijjo be balonda, it is not appointed, it is not military, nti elonda. That sort of distinction yenyinza okuteekawo, naye mujjukire disclaimer gye nabawadde.
Just to alina kyakaali n'ensonga gyayogeddeko awo, it derived it from your explanation, the first segment of Muhoozi obeera nti pursuing a political office while is still serving general. Nogamba nti if it was other officers, so wali baddewo some legal action to it. Naye tetulina kiraba ku Muhoozi. So tulaba president nti alina that immunity while is still in office. Mba temusobola kukola ki?
Kumukwatako.
Kuba mugaza amateeka okukola ki? Oba ne first son kirina engeri gyekimuwaamu awo liivu.
voice Musemateeka, there is no office of the first son to which privileges are attached. So, no, the office of the president privileges zefuna ziri for the president, not the family. Yeah. So you can take General Muhoozi to court. Of course, ensonga ekyokuba nti president tomukuba mu mbuga z'amateeka, you've seen how long cases take. Kesi ya Hame emaze kyenkana egenda mu myaka 5. So ku bintu kyekimu n'omulamuzi anyways, omulamuzi bw'aba akola omulimu gwe tosobola kuva eri n'ogamba nti decision yayisiza mu bukyamu n'endetera this amount of loss so nkutwala mu mbuga z'amateeka. Naye yabadde akola mulimu gwe, he did it as best as he could. Whether that was correct or not has nothing to do with the losses you incurred. So if you're going to subject a president to court process, aba alina okwapiaringa bamu-examining anaakoladde emirimu gy'eggwanga bw'aba agenze bweru. So oba ogenda kufuna a backlog of cases for the president, that is not the same with the first son. The first son is not any office. You're just a son. So ekingambisa nti if there was any other power, any other person, mba ntunuulira the facts that bw'otunuulira engeri eggwanga lino gye liri, waliwo professor bamuyita Ndere, Professor Ndere, anyways erinnya ndyerabidde naye no, I don't think it's Wabudere, but yagamba there are things that are on paper and then there are things that are real. Watch it out. So on paper he should not be doing that. Yalibadde tali, I don't know what the most recent campaign yabadde Teso. He shouldn't be doing that. You are a commanding officer of the land forces. Yeah, the command of the land forces. Tosobola kubanga commanding amagye ate kati oli ku rallies. No, it can't. It should, at least it shouldn't. I mean, we would say it can't, but it's happening. So it shouldn't be happening. So kyengambira nti if it was any other officer is that in reality, when we look at bw'otunuulira eggwanga lye tulimu n'engeri gye liddukanyizibwamu, mulimu ebintu ebimu ebyawandiikibwa mu mateeka, ndowooza abakulu ne bagamba ebintu ebyo bimanye we bikoma, birina bye bikwatako ne bye bitakwata. But ideally, and of course I think you've also seen that in the high political circles, including the president's office, mulimu a bit of discomfort that is being expressed from that office to do with this project. They are looking at the several challenges. It's almost that they would want to go that step of saying, you shouldn't go that far or else. Given the person who is doing it, ogenda wegendereza tosobola kugenda okumala gayingirira muntu oyo.
Oyogedde ku gundi eyo about a person taking legal action against the same, that there is mubayita your land friend gawaya tegule yachikola era akyali mu court. I think he's waiting for the pronouncement on the same. However, kati nembuuza, what are the chances of General Muhoozi appearing on the Ugandan electoral ballot paper? Nga one, achali tanaba ku retiringa, yatugamba ajja ku retiringa at 50. Then two, aina waliwo akakundi ICC, International Court of Justice, keyateeka ku mu list, andozera akakundi ye list, nga mulimu president, mulimu speaker, Muhoozi mwennyini. Then at the same time, he is not even a member of the most popular party, the ruling party, the NRMO. Ngate omuntu yena okustandinga for president at this time, asobola okubeera ne chances eziri highest okufuuka president ayina kubeera seconded by the NRMO. There are 3 questions in one.
Tutandike neya the likelihood of him being on the ballot nga tanna resigning oba tanna retiring. It is hard to tell kuba mulimu ebintu byetubadde nga ng'ogamba ekyo tekijja soboka kubanga amateeka tegakikiriza. But they change the law or they find a way around it. Naye if he's to do that bajja kuba bagenda kyusa etteeka nga bwewakiraba nti Sevo could have gone ahead 2021 nga tebajjewo kawaayiro 12 ba nga tebasoose kajjawo. Naye they went ahead and first removed it. So you will just have to look at environment eriwo. Do they want to change the law? But if they do not want to change the law, then he will have to retire. Kubanga retirement is not a very hard issue. You just put in your application. The commission nekukkiriza retiring. It is unlikely that commission is Uganda MCO retiring when he wants to. So it's not really a big thing. If he doesn't retire, he can retire. He will retire probably when he wants to actually take that office. So I think it is unlikely for him to appear on the ballot while still serving military office. There is a very easy option to exercise, which is retire. And of course, as president, you're still commander-in-chief. Obango, Omunamaje, you're an army without, you're an army officer that is inactively active. What should take away? So I think it is unlikely. Then ICC, but international law. International law, I know is that jurisdiction here court is international. Jurisdiction, we're talking about jurisdiction, we're talking about bw'oba olina ekintu ky'ogenda okukola naddala mu bintu by'ekooti nti olina jurisdiction okuwulira a certain matter, kiba kitegeeza nti olina authority, olina obuyinza obuwulira ekintu ekyo. So jurisdiction esobola okubeera ya mitendera mingi, esobola okubeera geographical, esobola okubeera pecuniary, esobola okubeera based on subject matter. Bweba geographical, kansooke ntandikire wano muze Uganda. Tusobola nti magistrates court oba chief magistrate w'e Masaka tasobola kuwulira musango ng'omusango oba the things or the subject matter naye okwogera oluzungu n'Oluganda where the facts giving rise to the case were in Kampala. Chovola a while back, I think here 2018, where they had to transfer these people. Was it Arua? The
politicians?
Yes. Because when the matter arises in Arua, it is to be heard in Arua. That is at the chief magistrate.
That's geographical.
Yeah, that's geographical. But the High Court here, never go back with the guru. Etule Kampala negulira. Of course, there are other smaller matters. It would be very foolish for you to file a matter in Kampala, in the High Court of Kampala, when you have the High Court of Gulu. But that is not to say that the jurisdiction of the High Court is limited. The chiba is that the High Court of Gulu and the High Court of Kampala are one and the same. Now, bw'otunuulira pecuniary ebyo biba bya ssente nti chief magistrate tawulira musango gwa ssente ezisukka kati kangeraageranye na magistrate grade 1 ne chief magistrate grade 1 tawulira musango gwa ssente ezisukka bukadde 5 bw'oba bukadde 5 aziteeka mu chief magistrate gy'oba olaga, that's pecuniary nti ssente z'oba eziba zikwatagana n'omusango gw'otwala mu kooti zisobola determining which court you go to. Then bw'oba otunuulira subject matter nti the very matter that you're taking to court, the court gy'ogitwalamu erina okuba n'obuyinza obuwulira that matter. So only the High Court can hear a murder case. Nti wewaawo obutemu oba ogenda magistrate court just to mention and then you're referred to the High Court. So that is the subject matter. So mbifunziza kubanga tulina ebingi ebyokwogerako.
Temulimu something to do with expertise. Because mpuliranga criminal lawyer.
No. The jurisdiction attaches to the court, not to the lawyers.
As in lawyers. Nenga bunga abalamuzi tebabeera konti naye expertise mu kino.
They do. Naye you would be expected to be able to handle whichever. Kuba basobola okujja mu criminal court ne bakusuula mu land division. Basobola okusuula mu family division. So you should be all encompassing as a judge. Yeah, but that has nothing to do with jurisdiction. Now, when I talk of jurisdiction here, ICJ, that is, first of all, emisango gy'ebeewulira gitera kubeera gya mawanga. Nti eggwanga erimu lituto eggwanga eddala before that court. Ekyokubiri, those countries must consent. Zirina okukkiriza nti we shall subject ourselves to the jurisdiction of this court. Again, bifunziza, there is a lot more to it. But why do I bring up jurisdiction? Nkulaga the challenges that international law has. It is a weakness. International courts can pass something. You've seen warrants being issued by the ICC, but they don't have a means of enforcing. It is up to the country that is in which the person is said to be. Okugenda nekwata omuntu oyo nemuwaayo. So ekyokuba nti Muhoozi yateereddwa ku okayisa kaki
ICC, there is that group, a list.
Wagambye ICC. ICC yanjawulo ku ICJ. Naye sigenda kuddamu kubinyonyola. But it's the same challenges. The challenges you have with the ICJ will still apply to the ICC with a few exceptions. So bwaba ateereddwa ku kagundi ako aka ICC nga bw'okayisa mu Luganda list ya ICC.
Naye nga tannaba kubeera indicted.
Tannaba. But even if he was, those courts, that would have nothing to do with his eligibility for presidency. Kubanga oli ajja kugamba, ssemateeka waffe agamba ki ekyetaagisa omuntu okuba president. Alina kubeera mutuuze wa Uganda. Buwera nno bulinga busatu. Naye ekyokuba nti you're listed in the ICC is not one of the things that can prevent you. That is within the courts of Uganda. Bobanga, you've been charged within the Ugandan courts and convicted, then you can start talking about limitations. Naye ekyokuba nti the man is listed, it has no import. Mpoza abannayuganda maybe kiyinza okwaffectinga eri ne bagaana naye ono omuntu ICC gwetunulamu, but legally he can still stand. Then ekyokusatu, waliwo ekibuuzo ekyokusatu kyewataddewo okyerabidde
otututte speed.
Netoloddemu naye the point I was trying to stress is international law has many weaknesses, one of which is its application to national systems. Wabeerawo obubuuza bungi, and of course bw'otunuulira government setups ng'ezaffe, applying international laws and orders becomes very difficult. If the government does not want to,
that's enforcement.
Enforcement becomes an issue. So having him listed is not much of a problem for him.
Byebyo bya General Muhoozi through our in-house legal brain JK Ndawula. Yes, our next topic gyetuddako, omwami waffe Nagagga Tycoon, nanyini Simba Telecom, nanyini Skies Hotel, nanyini ebintu bingi nnyo, bamuyita Patrick Bitature. A few days ago, to be precise, a court y'e Bungereza, those gye bayita International Chamber of Commerce Court of Arbitration. Sijja dweruma. Yes, yasalawo nti Patrick Bitature asasule company gye bayita Vantage Mezzanine Fund 2 Partnership eva South Africa eyali initially eyamuula million 10 eza dola nga ye ayagala kuzinvestinga mu engeri gye bagiyita 14 unit Mayo Close Apartments and Skies Hotel in Naguru. Naye n'alemwa okusasula. Ebyaliwo mu kooti z'e Uganda byaliwo era baloya ba Patrick Bitature olumu ne bajaganya oluusi ne bigaana nga bulijjo. However, kati tulaba nti Patrick Bitature has been ordered by this arbitration court in the UK okusasula Vantage to a tune of over now 32+ million US dollars. Does this 32 million US dollar verdict apply in Uganda? Can it be addressed in the Uganda legal hemisphere at all?
Answer nsooke nyangu yes. Katika tujinyonyole. Arbitration is a different procedure from court procedures abantu abasinga ze bamanyi. When you ekintu ekireeta about arbitration, why it is now operating a lot, nsonga nyingi, but most first and foremost amakooti gayina emisango mingi gye galina okuwulira naye process ya kooti eba slow. Nti otwala omusango 223 kooti esookerwamu high court neumala okuwulira say 2 years later olina appealing. By the time you finish the Supreme Court omwana eyingira P1 amaze P7. Cases take 7 years even more. Mulimu egy'emyaka 10. So there was a need nti tufuneyo procedure etali that formal court process eri more expedient nti omuntu asobola otwala omusango ne guwulirwa mangu. Yeah. So awoleteramu arbitration. So arbitration is in legal terms, but it's a system. It's an alternative dispute resolution measure or system. Nti there is the court system of resolving disputes. Nti tufunyemu obutakkaanya tugeze mu court, but now there is an alternative. Waliwo emiwaatwa emirala. Muleta arbitration, muleta mediation, mulimu conciliation and all that. So arbitration kubanga it's like a lower level of a court, a less formal court, or a more informal court. Now, eyamba nnyo naddala misango nga gino, oba si misango, mu bintu nga bino ebya business. Kubanga one, you have very many advantages, confidentiality and all that, but most importantly, you as the parties, oba ogenze mu court ina procedures zayo zeyina okugoberera, regardless of what you the parties think. But with arbitration, the parties have a lot they have a lot of input. You choose the arbitrator, you can choose the law that applies, you can choose the procedure that is to be followed. You have a lot of liberty on how that matter will be had. So many big businesses can never enter an agreement etaina arbitration, an arbitration aspect to it. So arbitration tesobola kubaawo nga toyina ndagaano ya an agreement to arbitrate. Tutandikirawo. So ensonga endeetera okunnyonnyola these things is Bw'omugamba does it apply in Uganda? You're not talking about a court judgment or a court decision. You're talking about what we call an award. But where does the award come from? It comes from the fact that this is arbitration, not court. So Uganda London court, yes. To the layman, you can interchange the things. Nae zibera arbitral tribunals. So, to the best of my knowledge, Mezzanine, Simba Manu, and all the other parties had an agreement, a base contract of the 10 million USD. And then I'm certain that within that agreement, there was a reference to arbitration, refer the certain disputes to arbitration. So, this a transaction or an agreement of that caliber, will probably have a separate arbitration agreement. So in the contract, there is a contract that talks about you're giving me 10 USD, I'll pay you back and all that. And then there is a clause within that contract, Gamba, if there is any dispute that arises in relation to matters, as a contract, they will be referred to arbitration. Boteka clause eyo mu contract yo kiba kitegeeza wogenda mu court no nti tubadde n'endagaano erimu that arbitration clause bwe tunaagenda mu court njagamba nti court eno teina jurisdiction ewulira musango guno kubanga tuyina an arbitration clause. So you don't need a separate agreement for the arbitration clause to operate. Usually when the higher the stakes, the better it is to have a separate agreement talking about your arbitration. So it's likely they did. Kati mundagaano eno kyenawulira is that this is hearsay. Naye siri mu court. I will rely on hearsay. Kyenawulira nti the arbitration agreement did not determine the seat of arbitration. Bw'oba ogambye nti you have an arbitration agreement, osobola okugamba nti musango gujja wulirwa mu Uganda, the matter will be heard in Uganda, oba tujja gitwala mu nsi endala. You could have many reasons for that. Maybe the other legal system is preferable, whatever the reason may be. So the agreement permitted Mezzanine, I think either party, to choose the arbitration seat. Mezzanine chose London.
London. Chova Justice Boniface Wamala. Yagamba having found that the impunged arbitration agreement exists and is valid and capable of being performed, and that there is an arbitrable dispute between the parties, it is considered that this matter be and is accordingly referred to the arbitration in accordance with Section 5 of the Arbitration and Conciliation Act.
Yes. So that act that is referring to actually some issues to do with jurisdiction. Kubanga court enkulu, that's the High Court, Uganda. Constitutionally, it has unlimited original jurisdiction, which means tosobola gamba nti the subject matter does not fall within its ambit. Tosobola gamba nti geographically or pecuniarily and whatever other reasons you may base on, the High Court can hear any matter. Naye that act, the Arbitration and Conciliation Act, egamba first and foremost under Section 9 ekugamba nti bwoba where the act applies, and that act will apply the moment you have an arbitration agreement. So where the act applies, court tesobola kwenyiga mu nsonga ezo. Ekintu ekyo kireetawo nnyo obuvungo mu bannamateeka abagana naye kati waliwo the unlimited original jurisdiction eya High Court. That section is now trying to, it is contrary to the Constitution. Anyways, those are legal arguments as well. But ideally, not ideally, certainly, akawaida ako kyekategeeza is that once I have an arbitration agreement, waliwo ebigambo omulamuzi owekitiibwa omulamuzi byakozesezza. One, there is a valid arbitration agreement. An arbitration agreement could be invalid for various reasons, but once court etuula n'egamba nti it is valid, two, the matter gyoyagala okutwala arbitrable, the matter gyoyagala otwala mu arbitration can actually be subject to arbitration. Kuba oyinza okwagala okutekinga something to arbitration ng'amateeka ga Uganda tegakikkiriza nga kirina kuwulirwa kooti zokka. So if the matter can be subject to arbitration, that's two. Then bw'ogenda mu kooti ng'owekitiibwa omulamuzi bw'agambye n'otwalayo omusango, once they find that the agreement is valid, the matter is arbitrable n'ebigenderako, bajja kuzaayo, bajja kugala sokoddeyo mu arbitration. Kyekyo ekyali mu musango ogwo. Then of course waliwo the decision of Justice Sekana yali egamba nti Mezzanine is an illegal entity and what not. Then Mezzanine proceeds to auction properties, advertise them. Ne babatwala mu court before Justice Mubiru n'abigoba. Nagaye ebyoggalamu, this is not a recognized entity, it is a non-existent entity, and therefore the agreement was invalid and whatever. That argument does not work here. Ojjukira nti eyo argument bagikozesa Muhammad. So they are trying to bring a similar argument. Yagigoba. So they had to go for arbitration. And the other thing is, an arbitration agreement, never to what cause endagano, until the $10 million agreement is invalid. The arbitration agreement is still valid. So ojagenda to the arbitration tribunal to determine whether the contract of 10 million USD is actually valid. So arbitration is very much supported. In CSC, it's not just Uganda. In the UK, actually, UK is very popular for having many arbitration institutions and many international businesses. Bwe ziba za kulonda an arbitration seat zigenda UK, particularly London. So that is what happened here. These people had an arbitration agreement. Mezzanine chose London as the arbitration seat. Omulamuzi n'abagamba mugende for arbitration. That is how this matter crosses over from Uganda to the UK. It is not going to an English court. It is going to an arbitration tribunal in London. So of course, from the facts that wafunye it was a one individual. An arbitration tribunal can be one individual or three. The parties just determine wabera muntu omu, you both agree on who it is going to be.
So both parties agreed to this
auditor, Professor Auditor. They agree. Tozobola kuleta going nti this arbitrator is going to arbitrate, and I have objections to it in the Tugenda mass. So once I have an objection, we have to get one to whom we both agree. If not, a court eja kusalawo, eja kumulonda. So you see that kind of freedom. Ekisoka mulonzo omulamuzi. They've not just assigned, unless you've gone to court netuga tulemeddwa okukkiriziganya mutuwa omulamuzi. But otherwise, you choose. And if it is three, each party chooses one, and those two choose the third. That is how an arbitration tribunal will be constituted. Netula. Kati that tribunal has authority to determine its own jurisdiction. Esobola okugamba nti guno omusango tusobola okuguwulira oba tetusobola kuguwulira. You don't have to go to court to determine that. Era bw'ona agenda mu court ejja kuzzayo egambe this tribunal can determine that issue. Of course, the matters mulina okubanga mwakkirizganyiza kuba you could have an agreement where not all disputes shall go to arbitration. Muyinza okugamba nti zino ne zino arbitration zino ezisigadde tugenda direct to court. Those things are all considered. And then once you're done with that process, that arbitrator will, of course, they sign their thing, but we call it an award, an arbitral award. Cutting a mazoba that bug, I hope it was relevant. Now you will understand.
Was it relevant? And never more relevant. Sinaye.
Nga tonayingira kuba njagala nsooke mala ekibuuzo kyona amanyi okubyerabira nange nebyerabira. So when you're looking at an award, this is now you're in the realms of international law. So awards are enforceable. Nti yadde yafulumidde UK, it will be enforced in Uganda. But tunulira sections, I think from 39 to 44 of the Arbitration and Conciliation Act, as well as 34, 35 and 36. Zikuwa engeri yoko enforcinga an award. So 35 ekugamba, when you have your award, make an application. Of course, if there is no objection to that award under 34, make an application to the court. And then when you make that application to the court, it can, of course, you attach the award itself and then your original arbitration agreement. Then it can give you a go-ahead to enforce. Once that go-ahead is given, under Section 36, you proceed and enforce it as though it is a decree of a court in Uganda. So, Botunuida sections 40, I think it is 43, 44, on that, and a bit off by 1 or 2. Was Tunulidezo, they talk about what they call the New York Convention awards. So, as to the best of my knowledge, the UK is a signatory to the New York Convention. The Chigwayo New York Convention on the recognition of arbitral awards. So, the UK is a party, and so is Uganda. That is why under the Arbitration Conciliation Act, Uganda, they recognize New York Convention awards. Even under the Arbitration Act 1996, UK, they also recognize those awards. So I'm not sure which type of award this one is. That is another disclaimer I should give. I have not read the awards. I have not seen their agreement, but I'm drawing conclusions based on the facts. So, Bogament, is it enforceable? I will say that it is. All that Mezzanine now has to do, of course, I think the lawyers of Bitature will invoke Section 34, I think, a challenging an arbitral award. So they will invoke it, they will determine their grounds. It gives several grounds for challenging an arbitral award.
He's trying to induce.
So, Boba to know the day, Boba agenda challenging an award. You have this particular. In the UK, their grounds are limited, but here these ones are extensive. I think, in consideration of the fact that Boba agenda mu court to challenge some things, wajakuza to the arbitral tribunal. So if the award is given and you raised those issues in the tribunal proceedings, then when you go to court, you can say that I'm challenging it on the basis of these things, and whatnot. So, bintu bingi byosobola okubesinga koyinza okugamba nti all the way from the agreement was invalid. You can raise that to challenge the award. You could say that maybe there was corruption, there was fraud, and all that. You can have many grounds to challenge in Uganda. So they can challenge that award. But it is still enforceable. Those are two things. It is enforceable unless it is successfully challenged. If they successfully challenge it, then court has options. It could send them back for that for that award to be reconsidered and all that. But you should know that if Mezzanine wants to enforce it, can go ahead. If Bitature wants to object to that award, he can still go ahead. The law permits both sides.
Nina chemade no nyamu on some facts so you can ezeko putting across without having the real facts. In the results of arbitration, Zigavanti, Bitature, I know quality of Sassola advantage Mezzanine. Na ye arbitration include them agreement, something to do with agreement. Something to do with reconciliation. Reconciliating the two parties. How then Boyamba njagade kutabaganya the two parties. When take out these other fines, you must pay this other than just kudiza chicho. No buntu obutonotono oli bwaba akoleseza. Naye ate no paying on to these other fines, money what.
Oh. So, okay, you're kucha conciliation, not. So reconciliation is different from conciliation. Conciliation is a different process, very, very informal. Conciliation is the ones who are mutitu iseba chief or to iseba elders. You mutelo kula twaliga tula films za Nigeria ezabiranga mu ebintu ebyo. Nti never janga besi beziresu bayambalanga lesu. Never tula wansi wo mutiku. That is conciliation. It is very informal. So, sisubiranti you can never get an agreement of this nature being subjected to conciliation. Mediation, I still don't think it would. So conciliation is separate. Now, why do they go ahead and give these things? This professor auditor, that man is very, very experienced. He practices in the UK, practices in Nigeria, and he's an experienced arbitrator. So, and I think, of course, now in Gambia, the parties have to agree to the arbitrator. So, echokubanti yagaseko these other fines, costs, and whatnot, that is acceptable in arbitration. Kubanga means okuba fine kubanja just obukadde asatu mu bubiri, but I've spent on lawyers, I've met some certain other expenses. We are paying the arbitrator. Arbitrators tebakolera bwerere, and given that one, I think he was a very expensive arbitrator. So you have to meet my costs. Remember, this is part of an initial. It's a different transaction, and then I have to get off of that money and start meeting these other expenses. You may as well not obanga as impact day. So they add those other costs, and of course. There were many parties. It wasn't just Bitature and Mezzanine. Bitature, Mezzanine, his different entities. Simba Properties. So there were many parties. So waliwo Bitature yengo omuntu zaino sasula. Waliwo his companies zaino sasula. So they are different. Again, nga wenagambye that award sinagisoma, nor did I read the agreement. But I think that when he comes to those figures, I know okubanga inakoya since that basing on the facts ezabadde mu bintu bino, basing on the evidence jaba yaise and all that. So reconciliating the parties, yes, you would like to do that in arbitration. And yensonga lwaki abantu bagenda nnyo mu arbitration kubanga bogenda mu court they sort of encourage this attitude of budget adversarial attitude. Timubanga abafu nga bw'obadde ogamba wano nti ojja kgenda mu kkooti olina munnamateeka wo n'oli alina owuwe mwe mufulume muli mu kuyomba
tetwagala kwetutunulako naye ate gwandifendinga oli outside yatuluganya mwina museka.
So there is that challenge with courts. The court is, when you go to court mubeeranga abagamba nti tukyalina bamikwano. But businesses will want to maintain certain aspects. Jesus can't find this transaction has gone sour. Now we have other benefits zetufuna mu kubanga tukwatagana. So arbitration is confidential soka. You're not compelled to disclose things. Or sobola certain information no sigenda jukwa for these reasons, right? Those things are not public. Unless, of course, certain circumstances come into play that necessitate its publicity. But they will not be public. So, the facts that these people raise, their arguments and all those things, they are confidential. So, that is why many people go to arbitration. Yes, there is an element of reconciliation. Nayenga when Nagambi, it's just a more informal court. So it may not necessarily emphasize reconciliation as such. It will attempt okugamba nti tugezeeko okusaving that relationship between the parties, but ideally they will want to compensate more than. So we're going to mediation, that is, the lower you go, the more reconciliation is a bigger factor to consider. So I think they might have attempted to do it. This one has soured very badly.
Ogambye, and I picked that word. Arbitration court and processes are very confidential. This matter was determined on 31st July 2023. And all of a sudden, every day.
Exactly. Tulimu August.
Could one of the parties be so grapping mutino yajitadde?
I cannot comment on that, with confidence. Kuba, I do not know why we are getting the information. I do not know who would have brought it into the media. Neiranga wogambye kuba nange nakirabe the award was given in July. Wano mubate munafuluma na court wali nga banamawulire basimbe. But this one, and by the way, them going to arbitration, it's not a process that started in yesterday. It's a process that started last year. So Bagenda, they chose all those procedures, never zitamu, never took okuwa award, and the country was quiet. That as such. So that is one of the big benefits. Now, why are we getting to know it? I do not know why.
And you can't answer.
I do not know why, but I think it is it's likely on the basis that now you're going to challenge. So you're going into the High Court. I think they're going to challenge it in the High Court.
What are the benefits of challenging that decision? Is it just to slow the inevitable?
Chiba chesinzira ku. It depends on the facts. It depends on the grounds of challenge. Chobo inokumanya is that the whole purpose of arbitration is to ensure that matters zikomekerera mangu. So if we just willy-nilly, if the courts just willy-nilly allow people to appeal and appeal, otandikidde mu High Court, you're appealing to Court of Appeal, you're appealing to Supreme Court, and it lengthens the whole matter, the whole process. So webaletawo arbitration, when an award is given, challenging that award, just know that if you're going to challenge, the courts are disinclined to rule in your favor. Kubanga, the whole point of arbitration is ekintu chiwedde tetwagala ate mu kiwanvuye. So for you to go to the High Court, you must be very certain of your grounds zobesingako. I think here the grounds may be, I don't know what grounds they may base on. Naye ezisinga wano, I think they are eliminated. Bayinza maybe okugamba the nullity of the arbitration agreement. I don't know if they raised that at the arbitration. Whereas again, these are not public proceedings. They could have many grounds. Courts will be very, very hesitant to kukkiriza your challenge. Once you accept the challenge, then you've re-entered the formal system that in the first place you mwali mugezako ku avoiding. So, yes, there is and everyone can go to court, but you can be thrown out just as easily.
Everyone can do what?
Yeah, you can go to court,
but you can be thrown out
just as easily as you've gone to court.
Just as easily,
if not easier. So, yes, they definitely can challenge, and I think they will challenge. The benefit, of course, is that this is a lot of money. Kuba abantu bagamba 34, but that is not the end of it. There are other fees, as Zaino suspects. It's a lot of money. Ajja kwagala okuzitaasa. Kuba ogambo ayinza n'okuba taziina right now. Ne bogamba nti they take properties. I don't know if the properties that are attached are worth that money. Wabanga yaziteekamu obukadde 10 fine, you can consider other factors of increasing their value. But altogether, you're looking at 32.25 as an individual. Omanya omuntu okusaba obukadde 25 as an individual.
Ate muzino mulimuko ne interest.
Yes, mulimu interest, 13%.
Because on your phone, it was extended at $10 million.
No, even leave that interest. An award can be given interest.
That is the 13?
That 13%. I think, I remember the figure is 13%. So that is a lot of money. If you have a way in which Joso will gamba until no, that again that disasula, you would take that opportunity. So I think they will challenge, and the point is either to have the arbitral award revised, maybe reduce the sums, but whatever reasons, they're going to challenge. But it has a benefit to it.
Yes. Thank you very much, JK Ndawula, our in-house legal brain. It has been a tremendous journey through the legal maze. Until next time, bye-bye.